The views and opinions expressed by guests on this podcast, including doctors, prosecutors, and representatives from various government departments, are their own and do not necessarily reflect the views of the podcast host or any affiliated organizations. The information shared may be based on personal experiences and professional insights at the time of recording, and these views are subject to change. Listeners are encouraged to seek professional advice and conduct their own research regarding the topics discussed. The podcast is intended for educational and informational purposes only and should not be considered as legal or medical advice. Good evening. Welcome, ladies and gentlemen. I'm Kolani Gaya. Welcome to In Your Face podcast. Today, today we have a very special guest. We have Advocate Van Wyk. Welcome, sir. How are you?
Thank you for having me. I am doing well, Mr. Guy, and yourself?
No, I'm alright. I'm alright. Can't complain. Uh, Firstly, let's get to know Mr. Van Wyk. Who is Mr. Van Wyk?
I am Tevane Van Wyk, long name, but for short Tev.
Alright.
Born in the Northern Cape, grew up in Gauteng,
Mm-hmm.
Pretoria, so I call Pretoria home. I've been back in the Northern Cape for the past 11 years
Okay.
for my career.
Oh, okay. Your career, like you just highlighted. What is it that you're doing? What is Mr. Van Wyk doing?
I am a state advocate,
Okay.
so also known as a prosecutor. I represent the Sexual Offences and Community Affairs Unit within the NPA.
Mhm.
So my job is to criminally prosecute cases of a sexual nature.
Okay. To which unit are you attached to?
It is SOCA, which
Okay.
stands for Sexual Offences and Community Affairs.
Okay. Now, can you just go into your experiences as an advocate? What are the challenges that you would normally encounter as a state advocate dealing with sexual offences
The biggest problem we're facing right now is that our complainants are withdrawing cases.
matters?
And we don't know whether it is a lack of awareness in our communities with regards to the criminal procedure that we follow at our courts, or whether this is just societal pressures that are forcing or allowing women to withdraw cases. But that is a big challenge because you sit now with an unwilling victim that you want to turn into a survivor,
Mm-hmm.
but they're not willing to come on board so that we can prosecute their cases. So that is the major challenge we face as prosecutors of sexual offenses.
Okay, but why is it important for you guys to prosecute sexual offenders?
The most important thing is there's a wrong that has been committed,
Yes.
and we need to be in a position to bring that victim into a space where he or she becomes a survivor.
Mhm.
And the criminal system is important for that because once you are convicted,
Mhm.
your name is entered into a register nationally. You'll not be able to work with children or do foster care because you've been committed of a sexual offense. The other importance of prosecuting these cases is to ensure that it doesn't happen again, at least not by the same perpetrator.
Okay.
And hopefully, we send the message that other would be perpetrators will be punished accordingly.
Okay. Now I want us to go into the sexual offenses. What are these sexual offenses? Let's say for a lay person does not understand what is sexual offenses. Now, if you have to engage that particular person and try and make them understand, what would you say is a sexual offense?
Okay. Sexual offense would be any behavior, conduct, which to your body, your person, if somebody else invades that space or touches your body without your permission, that would constitute a sexual offense. So there is no consent for them to touch your body or to use your body in any sexual manner. That would constitute a sexual offense.
Okay. Now, the other thing that I want us to touch on is you spoke about the importance of people reporting matters and later on withdrawing the matters. But what is wrong with me withdrawing the matter? The perpetrators, let's say, for example, is my partner or as my uncle, and I decide that I want to withdraw. I no more wish to proceed. What is wrong with that?
Remember now, when you've committed a criminal offense, you've committed against a specific individual or a specific group of society. But more so because the Constitution empowers the NPA to prosecute criminal offenses. You've wronged the state. So you've wronged the whole Republic of South Africa. And that is in that might and power that we must prosecute. Now, let's say, for instance, I do end up withdrawing that case. And tonight, when that person goes home and they're killed, it will be up to us to answer because we had the power to stop that from happening. So that is why it is so important that we do not withdraw or allow the withdrawal of cases.
Okay. Now, the reason why I asked that particular question was because of you go to court as the complainant or the victim. You know, say, no, but I want to withdraw my case. And then you are told, no, but this is not your case. This is the state's case. So that's why I wanted us to touch on that issue of saying, but this is not your case. This is a case that belongs to the state. Ne? Now, I want us to go into the victims. What tips can you give to victims? Tips, advice that you can give to victims of sexual offenses?
Okay. Firstly, I would say is that you, through reporting, that's when you take your power back, and that's when you exercise the protection services of the state, where we are called upon now to protect you, right? The other important part of reporting is that in that way we get to give you psychosocial services. So if you're in need of counseling for the trauma you've experienced as a victim, where else would you go to where you would get these services for free other than through the state? And if just on that point, Mr. Guy, I can indicate to you that um, the Tutuzela care centers in our country, they are tasked to provide a safe place for our victims.
Okay.
Once you make use of those services, you'll be empowered by, there is actually a victim assistant officer who work out a whole safety plan with the victim. So it would be such as, if a group of young people are going out, stick together, go to the bathrooms together, send your location to your friends if you are perhaps meeting somewhere out of your comfort zone, so that people at all times know where you are, or even just leave your app, your phone settings to allow them to track where you are. So those are some safety tips we can give you. And of course, meeting with strangers comes with its own dangers.
Yeah. Now, I want us to say, how can witnesses best be supported during a criminal trial? How can we, as no, like family members, friends, colleagues, how best can we support this?
Okay. What we have within the NPA are court preparation officers. They are usually social workers that are trained within the NPA. They are trained on our court processes, which we will touch on within this session. Those CPOs, as we call them, they sit and they see where there are needs analysis that need to be made regarding a victim, whether it is again psychological services or safety services, but more so they explain the role of each role player within the system. So they explain to you what the prosecutor does, what the magistrate does, so that victim understands the entire process before making a decision, especially with regards to withdrawal. That CPO also stays with the victim while they're at court. So the CPO will actually sit inside court while the witness testifies. So you have that support and that comfort of knowing there is someone there who's looking out for your best interest all the time. So our victims are not left unattended once they come to court.
But now, how important is it for the investigating officers to ensure that they do their work to the best of their abilities? How important is that in helping you deal with the matter? I would want to believe that it is important for these different parties to play their roles. So important is it for an investigating officer to do things accordingly, because of there is this perception that police officers are not committed or they do not do their work.
Okay. In terms of the South African Police Service, they are first line of defense
Yes.
when it comes to combating crime and preventing crime. So it is the unit that deals specifically with these cases is the Child Family Violence, Child Protection and Sexual Offences Unit, FCS. They deal with all of these cases. So they're specialized police officers who are educated on how to deal specifically with sexual offenses. Now, it is so important that they conduct investigations vigorously and with the utmost respect for the victim, because every sense of information that comes through the investigating officer is what I get in my docket, and that's what I bank my decision on. So if I don't have all of the information related to that offense in the docket, immediately I have to call upon South African Police Service and ask them why it's not there, and then also to instruct them to provide it. So it is vital that they play their role in collecting evidence and making sure we bring perpetrators to book.
Now, the other thing is, how important is it for the police officers to maintain communication with victims and witnesses in matters? We've heard of matters whereby person is a complainant, uh, they went to register a matter, but they do not know as to how far is the matter. So, how important is it for them to communicate such information?
Okay. They are obliged to communicate every postponement of a case with the complainant. They are obliged to inform them as to the reason of each postponement. If the matter is not yet before the courts, the investigating officer is still the first line of communication with the victim to say that the prosecutor has read your docket and this is what they are querying or what they want clarity on, but the investigating officer must be the person and is tasked so by law to update the complainant on any movement or changes regarding their criminal case.
Okay. Now I want us to go into the gender-based violence and femicide.
Yes.
I believe that also falls under your unit. Eh?
Yes.
Yes. Now, I want you to give us, or rather to try and help us. I'm a victim of GBV. Where do I go if I want to report that?
Okay. So as I tell when I go to the schools and when I speak with other stakeholders, state departments and so forth, I always explain to them that we don't always have to go to the police. Sometimes you might feel stigmatized by going to
Yeah.
the police to report it. I always say, especially to children, is to tell an adult. And if it is someone within the home who's the perpetrator, to tell an adult outside of the home. But we have other reporting avenues for domestic violence. For instance, the Department of Justice has an online service where you now apply for a protection order or harassment order
Okay.
online. And even if you do not complete your application, you still do get a court date. And you can always go back and amend that application until it's complete. The other avenue is also the Khalishiwe TCC, the Khalishiwe Tuduzela Care Center, is also at this stage starting to take in applications where you can go and visit them at their hospital. They take applications for domestic violence as well. So you don't have to go to the police to report, especially if you're afraid that people will know that you're going there to go and report. So we have different avenues where it can be reported. And remember also, any official or any educator or social worker who's aware of any form of violence against a child or an older person, he has a duty legally to report that. So we have different avenues where you can report domestic or GBV related matters.
You know what happens to a parent or somebody who's aware of such, but they do not report it? We have incidents whereby in families, the father is the one who is perpetuating such on the child who is a minor. Now, the child will tell the aunt or the mother, and they're like, we're not going to report this
Mm,
because of this is the breadwinner.
mm.
So once this is reported, hey, it's going to be problems. Now, that's where I'm coming from
Mm,
with my
mm.
question.
Yeah. What we do is, especially where there's a child involved, we try not to remove the child from that environment immediately. We try to remove the perpetrator.
Okay.
And what we do when we consult with them as prosecutors and when they come to get our other services, such as through the TCC or through the court preps, that is when we explain to them safety protocols that they can follow, right? And even when it is the breadwinner, we indicate to the families that although it is that this is the breadwinner, there are other avenues where the state does provide grants that can assist the families. So they need not be fearful of reporting because it is the breadwinner.
Mhm.
Um, Remember, there has been a wrong that must be punished,
Yes, yes, yeah.
and that is the main focus. We are victim centric, so
Mhm.
the victim comes first. So we will at all costs still proceed with the prosecution in that regard, despite it being a breadwinner.
Now I want us to move now from that. I want us to go into the court system itself. I want you to help our viewers explain to them what happens. I'm a victim. Go to the police report. Want you just to break it down to us so that our people can understand how does this whole thing work.
Okay, so let's say you do start at SAPS,
Mhm.
which I indicated earlier doesn't always have to be the case. Let's say you do start at SAPS, your case is then investigated, and it's now reached the point where it's ready for court. In terms of the SOCA mandate, we will ensure that there's counseling first and that you've seen a court prep before the prosecutor even consults with you. You'll then be brought in to consult with the court preparation officer and thereafter with the prosecutor of the case. The prosecutor then takes your case to court, presents all of your evidence, and the magistrate then will make a finding. The magistrate will make a finding of either guilty or not guilty. Should a perpetrator be found guilty, we then immediately move into sentencing, which we then make submissions as the state. The prosecutor makes submissions. The defense, who represents the accused, will also make submissions. And the court ultimately has the power to decide what should happen. And the court then will impose a suitable sentence.
Now, the other thing that I want us also to check, it's these terms that are being used in court. We would hear people saying, my case was withdrawn,
Mm,
and I don't know why was the case withdrawn, because that's what I heard. Now, there's another term that courts in courts they would use, which is struck off the roll, removed from the roll. So please just help us with that so that our viewers can understand next
mm,
time when they
mm,
are victims, when they are complainants, and they appear in court.
mm.
What is the difference between these terms?
Okay. So when a case is withdrawn by the prosecutor, it's when the prosecutor gets up in court and says, Your Worship, I'm withdrawing this case.
Mm,
And the state need not give reasons.
okay,
But for this platform, reasons might be that the complainant has relocated
okay.
and indicates, I'm not going to come back to this jurisdiction to proceed with my case.
Mm,
Or the perpetrator has gone. We don't know where he is anymore. In that instance, a matter can be withdrawn by the state. When a matter is struck from the roll, that is now the powers of the court that
yes,
it exercises.
yes.
So it has nothing to do with the victim or with the state. That is where the court says, but this matter has been on the court roll and it's not moving forward. It's not going anywhere. So I'm not going to give the state another opportunity for this matter to be before the court. I'm going to remove it from the court roll. But that simply means that the matter is not active before the courts.
Yes.
It is still active within the South African Police Service. It is still active for the National Prosecuting Authority. So, for the victim, in all intents and purposes, that case is alive. Once there's a verdict, then that case will become closed.
Okay.
But it is not closed if it's removed by the court.
Now, is it possible for a matter to be withdrawn, ne, or removed from the roll or struck off the roll uh, upon the accused person appearing for the first time in court?
For a withdrawal to happen in that situation, it would most likely be where the complainant has come with compelling reasons that will justify and giving the assurance to the prosecutor that this person will be safe, they will be helped further with services. In that instance, you might find that there was withdrawal on the first appearance of the accused, but it is something that should seldom happen.
Now, is it possible for a matter to be withdrawn by the state without having consulted the victim or the complainant in the matter?
Okay. Now, as a prosecutor, my first duty is to make sure in the docket that there's prima facie evidence. So that just means that there must be a little bit of evidence that connects the accused to a criminal offense and that this complainant or victim is the one who suffered as a result of this. Then I have a prima facie case. But if I don't have just that little, as I indicated now, for me to put the matter on the court roll, then the matter will be withdrawn and will not go to court.
But
So
no,
that is a possibility. Sorry, Mr. Guy. Sometimes where the evidence is so poor or the statements contradict each other so much that we could never possibly take this to court and win it, that is when a prosecutor will decide to withdraw the matter and to close it, and we will then inform the complainant of that decision.
Okay, so the complainant will be informed later on that the matter has been withdrawn or the matter, yeah, whatever that happened to the matter, will the complainant. Now, in the event that there's an accused person, there are issues, ne? And then the victim feels, but no, man, the accused person was favored by the state as a result of their position in the society or the community. Now, how does that work?
Yeah. I think a lot of times, Mr. Guy, there is that perception that accused persons are being favored. But we must remember, as well as the victim having rights, the accused also has a right.
Yes.
And it's a fundamental right contained in the Constitution in Section 35. They must have a right to a fair trial. In terms of our case law has said that the court must be fair to the state and to the defense. So what we try and do is a difficult balance of exercising the rights of the accused and the rights of the complainant. And that's where the court comes in because we are a party to this.
Yes.
That's where the court comes in and takes over and says, I rule in this way or that way to best suit the interests. But I wouldn't say that it's a situation where the accused is favored. Remember, if anything in the trial is done that becomes irregular or becomes disadvantageous to the accused, then the whole exercise of that trial will fall away. So we try and protect those rights as we go on with with the trial, and that is why the NPA is victim centric. We will always ask for the court to indulge us so that the victim can be suitably accommodated. But it is a fine balance between the rights of the two parties. It's a very fine, and will come down to merit. Which party's case holds more merit?
Now, there's, how do I put it? There's expectation from the society that once a person is being accused of having committed a crime, and especially GBV, first thing that must happen, that the person must be immediately arrested and kept in custody. Now, is that fair? Now, I'm asking you this now as somebody who deals with the law. Is it fair for our victims or the complainants to expect that from the courts?
It is indeed fair. Remember, there's an offense committed, and sometimes the offense is an ongoing one. And by the time it's reported, we have now only hit the tip of the iceberg. So it is fair in a situation where the police will use their discretion in terms of an arrest. If they see that the danger is still imminent or is existing at the time, they must effect an arrest. Um, the sometimes what will delay the process of an arrest, you might find that a complainant is not sober at the time of reporting the incident. At that stage, you cannot take down a sworn statement from that person, and therefore the police cannot act until they have a sworn statement. So you might find other challenges. Sometimes we have to shelter our victims before they can actually report the matter officially to the police. So there are a lot of other factors that go into um, deciding whether or not arrest should happen immediately. But it is a fair stance that our community expects an arrest to be effected immediately. And it is the case with most of our offenses, unless, as I've indicated, it might be an issue of sobriety or so.
Okay. Now, Mr. Van Wyk, let's say I'm a complainant, rather I'm a victim, I was attacked by whoever, and I do not report the matter immediately. Then I go and report it after a week or so. Now, what other implications in that matter?
Okay. Usually, where it is an instance where the person has been physically assaulted.
Yes.
Um, the one negative of not reporting it immediately is that we won't have evidence of the injuries that were inflicted, and we won't have that. We want to sometimes see that open wound.
Yeah. Yeah.
Because it adds more meat, if you can put it like that. But the negative, as indicated, is that we will not have all the evidence as fresh as it was. But the courts are not allowed to make any negative inference. So they may not make a negative finding because, for instance, in a sexual offense, you only reported the rape 20 years later. The law is very clear that says that there are no time limits on when you can report. But we must encourage our people to report immediately. And that is especially so that one, we can get the perpetrator, and secondly, so that we can preserve all of that evidence, which will be lost if you take time in reporting the matter.
Okay. So on the part where you're talking about the possibility of evidence, um, what is this? The evidence being lost. Now, how best can we remedy that as a victim of sexual, yeah. How best can you remedy this? Something happened to me. What tips can you give me? What do I do so that going forward they know?
Okay. We'll advise, especially for victims of sexual offense, is that you do not take a bath,
Okay.
do not take a bath, do not change your clothing. Um, also, do not make contact with the perpetrator in that time,
Okay.
because it's very easy for them to manipulate you into avoiding you reporting the matter. We would also then, if you have, for instance, changed your clothing, is to keep that under lock and key, so only if you have access to that. We'll say, for instance, things that were used means of protection
Mhm.
for sexual intercourse is to keep those. Keep those. They form key evidence for our investigation.
Now, if I may, I'll just give us like let's say one example. What would that be?
For instance, in let's say in a rape where the
Yeah.
perpetrator might have used a condom, is then if the condom is still at the premises where the offense occurred, is then to keep the condom, keep that condom. It sounds very weird, yes,
Yeah.
but remember within that condom is so much DNA, which is what we use in our sexual offense cases to link the accused to the victim. So it'd be to keep that if you were hit by a weapon, for instance, is to keep that weapon because it may contain your DNA as the victim as well as the person who perpetrated the offense.
Well, let's say the offense is you were assaulted. Is it advisable for one to take pictures of yourself and keep those?
Absolutely. I have in my training sessions when I speak with the South African Police Service, I encourage them to take photos when they go to the complainant, but also for the complainants themselves to keep photos. You can keep a sort of a diary, especially if it's ongoing abuse, is to keep a diary of the incidents, your injuries, and then to document them as you're indicating by using your phone. We have smartphones, or yes, so use your smartphone and keep track of the injuries. Take photos so that we can present that in court.
But now what if it's years, donkey years back, and then will that also help in court?
Indeed, absolutely. Remember, that will be real evidence, regarded as real evidence,
Okay.
as if we are seeing the person in that injured state.
Mhm.
So that is real evidence for the court. The court takes it as something that it can see and touch. So it still has a lot of evidential value. So we encourage victims to keep the evidence.
Okay. Mr. Van Wyk, there's also a perception out there, which is that an accused person would appear before the court, their rights would then be explained, and then the accused will say, no, I'll speak for myself. You'll have instances whereby the court will then say to you, no, go for legal aid. Eh? Go for legal aid. And the person would be like, no, but I don't want legal aid.
Mm.
Now, as a result of that, there's a perception out there, which is the courts or the court, the magistrate is working with the legal aid lawyers so that ultimately you can be found guilty.
Mm.
Now, I think, is it a myth or is it a fact?
It's definitely a myth, Mr. Guy. As at least 10 years experience as a litigant in the criminal courts, it is a perception that is amongst our communities. It's a very wrong perception. When you look at a person from Legal Aid South Africa, they are legally trained as much as I am as a prosecutor. We have the same law degrees that entitle us to practice law in the country. So there's no difference between myself and them in terms of qualifications.
Yeah.
However, the difference that is present are just the roles we play. Whereas the prosecutor defends the victim and the legal aid practitioner will defend the accused person. But there is no guy, we all go to the same university, so we all get the same education. So there is really no differentiation between ourselves and our colleagues who practice under legal aid.
No, but how important is it for one to be legally represented if one finds yourself in conflict with the law?
Okay. It is vital. It is vital. Whether you're innocent or guilty, it is vital that you have someone who is legally trained to represent you. When we speak in court, we speak the language of the court. And we do have interpreters who assist in the court, but the language of the court remains that. It's a very legalistic language. So you as the layperson now who is accused of having committed an offense, you are going up one man against the whole state. So going up against the prosecutor and the whole team, which is the state. It is SAPS, it is the Department of Corrections, it is everyone who, if for a better term, is ganged up against one individual. So without any legal training or knowledge of the criminal justice system, it's almost impossible to defend yourself. You won't know when it is your turn to sit or to stand or what to answer in court. So we fully encourage that once you are accused of criminal offense is to get legal representation.
Okay. Now, I think you earlier on explained the role of the magistrate. But now let's say there are people who believe no, magistrates are there just to convict you and punish or send you to prison. Uh, is that the right perception, or is it the correct thing, or it's just also myth?
Definitely a myth, Mr. Guy. If you look at a tennis match, you have your two parties playing here on the ground, and your umpire is seated in a higher position. So when you look at the roles in court, on the tennis scenario, you have the state and you have the defense here. They are busy hitting the ball back and forth to each other. The umpire sitting there to make sure that the game is fairly conducted, that is the magistrate. So their role is just to ensure that the proceedings are fair, but they're not to intervene with the proceedings down here. And so their job is to, they are a trier of fact. They must find out what the facts of the case are. And based on that, they must then, at the end of all of the evidence, they must decide, has the state proved its case beyond a reasonable doubt? In that instance, the court must convict. If the court is of the view that we have not proved our case beyond a reasonable doubt, then the court will acquit. So the court is not a rubber stamp for any party to court proceedings. The court is there as an umpire on its own. We're not answerable to each other as parties. So the court doesn't have a rubber stamp duty just to convict, no.
Now, there's another thing that I want us to touch on. As the different tests that are there in the proceedings. Now, we have a test which, your criminal case, would be beyond reasonable
Yes.
doubt. Now, what is the test in a bail application, or is it the same thing?
Okay.
So I want us to educate
Yes.
our viewers there. So, what is this test in a bail, and what is the test in a criminal matter?
Okay. I'll start with the test that's the most difficult test,
Yes.
is beyond a reasonable doubt. So I must be able to prove that it is this person who stabbed the other person, and that person did get injured. And of course, there was no permission to inflict bodily harm on another person. So I must prove that beyond a reasonable doubt, that it couldn't have been any other person but the person we are accusing. So that's a test for beyond a reasonable doubt. That's for the criminal trial. For the bail proceedings, it's only on a balance of probabilities. So it's you start off on a 50-50 scale, and then whichever party, the applicant, which is the accused, or the state, the respondent, whichever party flips that balance, is the party who's entitled to have the court rule in their favor. So the balance is not as high. Um, the, the evidence that the accused needs to produce is not as high as in a criminal trial when the accused is placed on the defense. So in the bail applications, it's much easier to discharge of your onus, and it's a reverse onus, which means that the accused must prove something and not necessarily just the state. So that would be the difference in the bail and the criminal proceedings.
Now that we have our society members who would feel once the person gets bail, chances of the person being convicted are zero, 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 zero. Now, is that the right thing that we should think
Mm.
as
I
the society?
No, Mr. Guy, I definitely disagree. When a person is released on bail, it means that that person has showed to the court, I am not going to flee the country. I am going to stand trial. I'm not going to interfere with the investigation or with the victim or victims or witnesses. So there are various factors under the Criminal Procedure Act that the court will say, I'm granting bail based on this. But the court also imposes bail conditions, such as you must attend your court hearings, you must not interfere with the complainant, and violating any of those will give the state the right to have your bail cancelled. Now, Yes, so being released on bail is not an indication of whether or not the state will lose its case. No, it's merely that the court is satisfied. It's in the interest of justice that this person be allowed out.
Now, are my views considered as a victim, as a complainant, in that whole decision of whether bail is to be granted or not? Are my views considered? And how
Absolutely.
important is how I feel?
Yes, absolutely. The first point of reference for the state in opposing a bail application will be the considerations of the complainant. How does the complainant feel towards the accused? What is their relationship? Is there likelihood that if the person comes out that they will be in the same dwelling again, the same house? Is there a possibility that this person might do me further harm? So the victim's views are crucial in deciding bail. And when the investigating officer testifies in the bail application, these views of the complainant will be ventilated. They will be placed before the court so the court can make an informed decision with everything in front of it. So the views are for the NPA, because we're victim centric, the views are vital in us deciding whether to oppose a bail application or not.
Okay. Now, Mr. Van Wyk, the other thing that I want us to touch on, I want us to move now a
Mm,
bit, the Domestic Violence Act.
mm,
Now, all that we know, Domestic Violence Act, it's like we call it in the township,
mm.
it's interdicts. Uh, Under what circumstances can I approach a court and apply for a protection order and for me to get a protection order, my application
Mm.
not being dismissed?
Okay. It'll be very rare of our courts to simply dismiss an application. From the applications I've seen, it will be very rare. The requirements are that you know who the perpetrator is. You would need you would need to prove either a pattern, at least, of abuse. If not a pattern, your latest incident of a domestic violence occurrence. That would be sufficient. Now, a domestic violence or a domestic relationship has now been amended as we used to understand it. So it used to be what we knew as boyfriend and girlfriend, husband and wife. That has been amended drastically now to be any person within your household, any person with whom you in a household or with whom you share a child or share rights in respect of a child, those are now considered as domestic relationships. So even those persons are now covered, which were not previously covered. So, sorry, you will bring application before the court. Depending on how urgent it is, it may be granted immediately, and you will have your protection immediately. Or the court will give a date where the respondent, the perpetrator, will now have to come to court and show to the court why an order should not be granted. But it is very rare that an order is dismissed, unless if the complainant will indicate to the court that I no longer need this form of protection, so I'm no longer going to apply for it. In that instance, it will be an easy dismissal.
Now, let's say my partner uh, decides to assault me, whatever, and it only happened that day.
Mm.
Can I still go to court after it had just happened once? Can I still go to court?
Yes, the mere fact that you are in a domestic relationship with the perpetrator, you can go to court immediately because you're seeking protection. And that is what the protection order is. It's to grant protection. So even if it is a once-off incident, under the Domestic Violence Act, you can definitely still get an order.
Now, what conditions can a court impose as far as the domestic violence order is concerned?
The court's powers are very broad in that. The court will consider the application, the factors in the application. So, for instance, that the complainant says, I don't want him to make contact with me while I'm at work. So, the court will make that an order of the court that the respondent is ordered not to make any contact with the complainant. So, um, the other orders the court can also make is that the respondent may not even come to the house where even the respondent resides because the complainant is there. So all of that will depend on the merits of the case, but the orders are very wide and the protection is very wide that is afforded.
Okay, can I just ask this? Let's say I'm working with somebody, we have something or we are romantically involved, sorry, and things happen. I decide to go in and apply for a protection order. Can the court impose an order that would say that I should not make contact with that particular person? Even though we remember we're working in the same place, can the court impose such
Yes,
an order?
absolutely. The court can order that there be no contact. Remember, if it's not in a position where you need to work with this person directly, but you share the same environment or working space, the court can definitely order that you not make contact. There are a lot of such orders where there are people working in the same building, but they're not allowed to have contact with each other because it's by court order.
But now we working. I need to now. Let's say we are at work. A meeting is called, and we all convene or assemble in one office. Can the victim perhaps call the police and say, "Ah, Mr. Guy has contravened the protection order"?
Remember now, Mr. Guy, we don't want to be malicious
Yes.
and we don't want to abuse the law. In as much as the law affords this great protection to our victims, we don't want it to be abused. That's not what it's created for. So, in that specific scenario, it would be a malicious complaint, and that could lead to a civil suit against the complainant.
Okay, because I wanted to understand that to say, but what would the recourse be in the
Mm,
event that a person becomes malicious
mm,
and they misuse or abuse the
mm,
order? I wanted to
mm,
understand that because we have a few people, or a lot of people out there,
mm,
whereby there are protection orders against
mm,
them, and the person would normally just misuse it, or if they
mm,
see you and they go and call the police.
mm,
This is,
mm.
and I want you to help us. What recourse do I have?
Okay. Well, the Domestic Violence Act as well as the Protection from Harassment Act make it very clear that any false statement given either to apply for the order or once you've obtained the order and in executing it, so having the police now go and arrest the person with a warrant. So any false statement made can lead to criminal liability under both acts. So it means if you do abuse the Domestic Violence or the Protection from Harassment Act, then you can be criminally prosecuted.
But how many people have been prosecuted for that? That you know of?
At this stage, I don't know. One must also remember that the amendments are fairly new. They've been in existence for only at least the past year. So the amendments are new, which is why SOCA, my unit, is mandated to train prosecutors and police on these amendments and especially to go into the communities and to inform them of these amendments so that we can indicate that false statements can lead to criminal liability.
Okay. Let's. I want you to give us more in as far as the amended act is concerned of the domestic violence. So, are there any other changes that were not there in the previous one?
Yeah. The biggest one, as I indicated, was that it would have been for if we were living together, that would have been the biggest requirement for you to apply for an order. But as indicated now, that even parents who don't live together but share responsibilities in respect of the same child, those parents are still in the domestic relationship. So that's an amendment that has come. One other interesting amendment also is that during the bail application, should the court become aware, and there's no protection order, should the court become aware that there is a domestic violence issue, then that court will turn the bail proceedings into a domestic violence inquiry.
Okay.
And the court is even allowed at that stage to then order for a protection order to be granted, and it will have the same effect as if it was done under the Domestic Violence Act. So, in your bail proceedings, the court becomes aware, because we're dealing with the Criminal Procedure Act, there's a domestic violence issue. It then converts its bail hearing into an inquiry, and should it find grounds to impose a protection order, it will do so. And it has the same effect as under the Domestic Violence Act.
Okay. Are you saying that the presiding officer will be busy dealing with the bail application, as empowered by this act now, to issue a domestic violence order? You will not direct you to say, no, you need to go to the domestic violence court and all that. So they are in a position to.
Absolutely, yes.
Okay.
They now grant the order then and there, and it will stay in force as the domestic violence order does for the rest of your life. It will stay in force. Another interesting amendment is also that persons usually could only seek relief under one of the two acts. But now you can receive relief under the Harassment Act, protection from harassment if there's a pattern of this type of abuse, whether it's sexual or physical, and you can still get an order under the protection order, under the Domestic Violence Act. And related to that, Mr. Guy, is that once an applicant for bail comes before court, in that bail application, the applicant must disclose whether there's any pending application under the Domestic Violence Act or the Protection from Harassment Act. Failure to do so is then also a ground for the court to refuse bail, and it will be seen as being dishonest with the court. So that's another large amendment that is also that is coming to into law.
I've heard there's something to do with the monitoring as well. If let's say in the event that I've applied for protection, or can also apply that the police also frequent my premises to monitor if everything is in order. Is that also?
Yes, indeed, that can form part of the court order to ensure that there is compliance with the order. Um, that is why the training that's being rolled out is so vigorous, and that's why we're going into our communities to explain that there is more police action being taken in circumstances like this.
But now, how effective is that? Is there anything that the police will have to sign, or you as the who's the applicant in the domestic violence would have to sign? Because I'm asking this. Let's say a police officer. We know the perception that is there about our police officer, that they don't do their work. They are lazy. I'm not saying yeah, not saying that. Now they can easily say, but I've gone to this person's place, and you see now how do we monitor that
Yeah. In that instance, it would be really from the complainant relaying to us that there's been an incident or there's been a disturbance, which will speak to their order. But in terms of us being able to monitor that from an outside perspective, that is not at this stage. It's not yet active. So it is up to the complainant in this instance where we rely on them to convey to us that they are aware of the monitoring, what is happening or that it is not happening, so that the NPA can then give instructions to SAPS.
Okay. Another thing that I want to ask: are officials of do I say the police, the other departments, are they, or can they turn a person away and say no, but what you just said does not meet the requirements for you to be given a protection, without taking the application and taking it to the person who's supposed to decide?
No, 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 Mr. Guy. It is only for a presiding officer to decide whether the grounds are sufficient for an order to be granted. The domestic violence coordinators, they are police officials that have been designated now to deal with domestic violence cases. They take down these applications. They have no discretion in deciding whether there is merit to an application or not. It is purely the presiding officer who will consider the application. So the police and any other admin clerk cannot decide and say, but there's insufficient evidence here for you to get an order. That is when our people must take action and go to the superiors of these people.
Okay. Now, I want this to also, because in most instances, uh, domestic violence victims are mostly women or females. Now, how serious would my complaint be regarded or taken as a male if I go to the police or even when I apply for it as well?
I think, Mr. Guy, we should start from the viewpoint that in our country it is how can I say the norm that women are victims, which is the majority of the cases. Yes, we must take into account the underreporting of men, of especially sexual violence and domestic violence. Our men are not yet empowered to the point where they can go to a police station and report it. Indeed, we do have reports of males as victims. Very few, though, very few. It is still a stigma and an educational aspect we need to sort out within within the state itself, within our organs, within the police divisions, within our social divisions, that we need to sort out and have people understand that males are human too, and they too can be victims of crime. I won't say that the males will be turned away, But I can say that there is definitely still that stigma attached to when a male comes for reporting. And that is what we each, as an individual and then as a public official, need to work on so that we can accommodate our male victims.
Okay. Now, what is it that your unit or your department is doing to bring awareness about that? Because I feel in most cases, like you just said, we have this thing that the victims are always females. Now, what is it? Are you guys doing enough? Would you
Mm,
say that you guys are doing enough to also educate men to say, but you also are protected under this
mm,
act?
mm. Well, that is now what we're doing now as we're rolling out our training, especially on the amendments, and also going to society where there are a lot of men's forums that have been established, where we will say that we don't discriminate, but we only want to speak to the men in this specific society, so that we can address them as one being perpetrators of most of the violent offenses, but also to indicate to them that you as a person have rights and that you need to exercise these rights. Now, as I indicated, because it's still a stigma and it's so deeply embedded in our society, it's going to take a while for us to get there and say that this male can say that I've been a victim of rape. But it is a paradigm shift that needs to happen, as I said, within each of us before it can be, before we'll readily see men coming forward and reporting this. So we are engaging communities to discuss this, but also with the officials who are at the front lines taking statements and giving advice for them not to treat a male victim any different from they would a female. So it is an ongoing thing.
Okay, no, I get that. I'm hoping that we'll really get to a point where men are also taken serious. Now, you mentioned something about men forums. If I want to be a part of these forums,
Mm.
where do I go?
Okay. For the issue of safety and protecting some of these forums, I will not name them.
Okay,
But what we do on a provincial level, even, we have segmented ourselves within the various districts.
okay,
That it is the stakeholders as we meet are would be the NPA, the South African Police Service, education, health, corrections. So most of the state departments where we have lobbied together and then segmented ourselves into the districts within the province where we go out to do education. So hopefully, with that route and pursuing it constantly, we'll be able to get the same protection.
okay. Now, how important is it for your department to also uh, educate or bring awareness to our minors, our scholars at
Mm,
schools?
mm,
How important is it? Because we've read in different publications that kids have been violated at school by fellow learners. So, yeah, man, what
mm.
is it that you guys are doing as far as that is concerned?
Absolutely. Well, once we have a spike in any offense at a specific school or an environment, it's now, as I've indicated, from this provincial task team, we segment ourselves and we physically, literally go to the schools. I personally do go and address schools where we do topics of bullying, of inappropriate sexual conduct, substance abuse, empowering them on reporting avenues. So the schools, as Soka, one of its legs is also child justice when a child is in conflict with the law. So we do go out to the schools. We have programs where we go out to the schools and we do educate them as well as the educators on the avenues that they should follow.
Okay. Now, Mr. Van Wyk, I want you to, like, in closing, now, is there any matter that you've dealt with that you feel that this one I touched me emotionally? After this matter, I decided that this is not for me, or no, this is what I
Mm,
want to do.
mm. Well, as prosecutors, I don't think we should become too attached to our cases, but we are human. I would definitely say a case that I dealt with in this year still, which it composed of a number of boys being sexually abused over a period of 10 years. And in the investigation, we also discovered that there were pornographic images of children, which myself and the police had to view. We had to look at these images so that I could formulate the charges. So I would say that is, um, well, they the accused pleaded guilty, so at least the boys were protected from having to testify in court, which is a good for us because just to limit that trauma that they would have had experienced. That case definitely for me was an eye opener to continue with my mandate in soccer as a state advocate to fight for our children, especially as a vulnerable group in our society. And in that matter, we managed to secure a sentence of 120 years.
Wow.
So it's definitely one of my highlight cases for me to continue.
Okay. In closing, Mr. Van Wyk, there's the community out there, our viewers, uh, those who are victims of domestic violence, gender-based violence, and the men. What is it that you would like to say to them?
Okay. Is that people, we are here to help, we're here to listen. The services are free, and we need to work together, society, to bring perpetrators to book because we're keeping quiet about offenses and we're letting them continue. Our children are being hurt. Our children need to be protected. So please, we encourage you, we beg of you to come forward and to tell your story, no matter how long afterwards, and the state will assist you.
No, thank you very much. Thank you. Today we had Mr. Van Wyk or Advocate Van Wyk. Thank you. Very interesting topic that we had today. And I wish our viewers will also take the time, listen, and then learn from this thing. So thank you very much, Mr. Van Wyk.
Thank you, Mr. Guy.
The views and opinions expressed by guests on this podcast, including doctors, prosecutors, and representatives from various government departments, are their own and do not necessarily reflect the views of the podcast host or any affiliated organizations. The information shared may be based on personal experiences and professional insights at the time of recording, and these views are subject to change. Listeners are encouraged to seek professional advice and conduct their own research regarding the topics discussed. The podcast is intended for educational and informational purposes only and should not be considered as legal or medical advice.